One of the most expensive myths in Florida divorce is this: once you separate, your money is yours again. That rule does not exist in Florida, and believing it can cost you everything. Today, I want to clear up one of the most dangerous misunderstandings I see in divorce cases: how Florida courts actually treat money, property, and debt when a marriage ends. Because Florida does not follow community property rules, we follow equitable distribution, and the difference matters. Florida's system: equitable distribution. Florida is an equitable distribution state, not a community property state. What that means is this: under Florida Statute 61.075, the court starts with the presumption that marital assets and debts should be divided equally, but the judge can order an unequal distribution when fairness requires it. That decision depends on factors like each spouse's contributions to the marriage, the length of the marriage, each party's economic circumstances, whether one spouse wasted or dissipated marital assets. This is not automatic 50-50, and it is never mechanical. What counts as marital property in Florida? In Florida, we don't talk about a marital economic community. Instead, we identify marital assets and marital liabilities. Generally, anything acquired during the marriage, whether jointly or individually, is presumed marital. The spouse claiming something is non-marital has the burden to prove it. And here's an important correction to what you may hear online: the name on the deed or mortgage usually does not control. If property was acquired during the marriage, it is presumed marital, even if it's only in one spouse's name. The biggest difference: no date of separation in Florida. This is where Florida law sharply departs from states like California. In Florida, moving out, sleeping in separate bedrooms, living separate lives, none of that ends the marital estate. Florida uses a bright line cutoff. The date that matters is the date a valid separation agreement sets, or the date the petition for dissolution of marriage is filed. Until that filing happens, income earned and debts incurred are still potentially marital. This mistake alone has cost people enormous sums. Paying the mortgage after filing, credits, and setoffs. You may hear California terms like Epstein credits or what's charges. Florida does not use those concepts. Instead, under Florida Statute 61.077, courts analyze credits for mortgage, taxes, and insurance paid by one spouse, setoffs for exclusive use and possession of the marital home, potential rental value offsets, but only if properly pled. These are technical issues, and how they're raised in pleadings matters just as much as the facts. Adultery, waste, and dissipation. Unlike California, Florida courts can consider misconduct in specific ways. While adultery does not affect property division by itself, it does matter if marital funds were spent on a paramour, assets were intentionally wasted or depleted. That kind of dissipation can justify an unequal distribution, and it can also affect alimony. Commingling. The virus is real in Florida too. One concept from the California transcript does translate well. Commingling acts like a virus. In Florida, non-marital property can lose its protection if mixed with marital assets. Once tracing becomes unclear, the presumption shifts toward a marital gift. The burden to undo that presumption is high. If you inherit money or bring assets into a marriage, how you handle them matters. Businesses and goodwill. For business owners, Florida law now requires valuation of marital business interests at fair market value. A clear distinction between enterprise goodwill is marital. Personal goodwill relates to the reputation and skill of the individual, which is non-marital. This distinction can dramatically change the outcome of a divorce involving a closely held business. Alimony, post-2023 Florida law. Finally, a critical update. As of July 1st, 2023, permanent periodic alimony has been abolished in Florida. Courts now only award bridge the gap alimony, rehabilitative alimony, durational alimony, all with statutory caps tied to the length of the marriage. Anyone telling you otherwise is working off outdated law. Florida divorce law is technical, unforgiving, and very different from what you hear online, especially advice borrowed from other states. If you're dealing with divorce, property division, or alimony in Florida, get advice that's actually grounded in Florida law. Visit nestlaw.com to speak with our team and get clarity before costly mistakes are made.